Thank you all very much for being here today for this webinar that is TMCEC is helping put on for the municipal courts. My name is David Slayton. I'm the Administrative Director at the Office of Court Administration. And the other folks that I'm not sure you can see them, but you will probably hear from them at some point along the way, perhaps. Several of the regional presiding judges for the administrative judicial regions are here as well today. We have just over 300 people on the call today, on the webinar today, and hopefully we can spend the next hour sharing some information with you. I'm going to try to successfully share my screen. If PJs can give me a thumbs up that looks right, that'd be great. Looks good. So again, thanks for being here with us today. We're going to go over a couple of things today. One is what are the latest emergency orders and the guidance that's been issued as it applies to municipal courts and how to try to operate municipal courts during the pandemic. Since this is a webinar being put on and there's several hundred of you, just so you know, everyone is muted right now except for the panelists. So we can't see you, we can't hear you. It's not like a normal Zoom call, but it's somewhat similar. Obviously, you can see us and hear us, but we can't see or hear you. At the bottom of your screen, you'll see a box that's labeled Q&A. And in that box, you can type in any questions that you might have, and that will allow us as panelists to be able to see any questions that you have and then be able to answer those either during the webinar or at the end. The chat feature we won't be monitoring, so if you chat at us a question, then we're unlikely to see it because obviously with several hundred people that can become overwhelming. So again, we encourage you to use the Q&A function on the platform here. I know some people may be watching this on the YouTube channel. Obviously, you can't submit questions through that to us, but for those of you who are on here with the webinar, you'll be able to do that. We are recording and streaming this webinar live so that we didn't want to, we can only have 500 people on here at a time and we didn't want to cap out. So it's being streamed over onto YouTube at the same time, but we're also recording it and we'll make the materials and recording available to everybody following the webinar. So we're going to jump right in here and get started. As many of you may have seen, the Supreme Court of Texas issued the 18th emergency order yesterday, yesterday afternoon, and that information was sent out to judges, clerks, and court staff on our listserv last night. That order, the 18th order, really extends and provides some slight amendments to the 17th order, which was put in place on May the 27th. And we'll go over some of the things in that. Before I jump into really what the order says, as you probably know, the Supreme Court, when there is a disaster declared by the governor, there's a statute that gives the Supreme Court emergency powers to permit them to enter these type of orders. And that's the authority that they've used since March the 13th to issue these orders. Their first order was actually issued on the same day the governor declared the disaster. So the 18th order, this is quite frankly, the first order has continued to exist in this form as the 18th order. So a lot of the things that are in here were in the first order. But a couple of things it does specifically that I wanted to go over with you today. One is it allows every judge, every court in the state, in any type of case, civil, criminal, whatever, to do certain things. And I want to be clear about one thing. It permits judges to take actions in certain cases, and then it requires judges to take action to avoid risk to court staff, parties, attorneys, jurors, and the public. So a lot of these things you'll see here, they are permissive or they're also mandatory if there's a need to do it to protect the health and safety or risk to those folks I mentioned just a second ago. So the first thing it does is it allows judges to suspend deadlines and procedures. So if there are deadlines in cases that you're looking at, or there's certain procedural requirements that would be necessary, you actually are permitted by the Supreme Court's order to suspend those orders until those requirements until September 30th. So the May 27th order was the first one to sort of put an end date on that. the 18th order it keeps that same date in place. And so basically the suspension of deadlines and procedures is permitted up until September the 30th. In addition to that, a couple of other things, I'm just sort of trying to hit the highlights. There's a lot in this order, but I try to hit the highlights that are applicable to municipal courts, is that it requires remote proceedings unless it's unreasonable. So the court actually says that the Supreme Court actually says that courts must use all reasonable efforts to continue to conduct proceedings remotely. And so OCA's guidance has said that, the reasonable efforts will be if the parties aren't able to do it, or it's unfeasible or not practicable. Obviously, as you look to having proceedings in your court, the requirement is still in place by the Supreme Court's order to continue to do those things remotely. I know many of you have been doing that over the last several months, and some of you have started doing even more of that recently, but that is required. Some of you have already submitted some questions to me even in advance of today's webinar, and I want to focus on one piece here. And in the order, you'll see under number 3, kind of hard to see maybe on the screen, but number 3, it says that the courts can take these actions without a participant's consent. Someone has sent in a question in advance saying, well, what if the litigants demand an in-person hearing or request an in-person hearing? The court's order makes it very clear that courts have the authority to conduct the proceedings remotely without the participant's consent. So in the cases where you have people who are demanding an in-person hearing or requesting an in-person hearing, that is really up to you as a judge as to whether to do it. But I would also remind you that the court's order requires you as judges to use all reasonable efforts to conduct those proceedings remotely. So just pure convenience of the litigants is likely not reasonable efforts to conduct that remotely. So again, you don't have to get the consent of the parties or the litigants to conduct that remotely. We'll talk a little bit about some of those issues as we go throughout the rest of this webinar, but I just wanted to answer that right up front. In addition, the court's 18th order continues the requirement that courts must comply with OCA's guidance for all court proceedings. And on the next slide, we'll talk a little bit more about what that is. But basically, that requirement is in there. And the order states that courts must submit an operating plan before any in-person proceedings can occur. Many of the municipal courts across the state have already submitted operating plans. Many have not. And so we'll be talking about what exactly is required in that in just a second. So before you can have any in-person proceedings in your court after June 1st, you have to have an approved operating plan in place and acknowledged by the regional presiding judge. And you'll see those on file on OCA's website. I'll talk about that in just a second. The last thing and the last kind of key issue for you all is that the court's order of yesterday prohibits jury trials in any court in the state prior to September 1st. In the last order, the 17th order prohibited that until August 1st. This order now moves that date to September the 1st. The order actually does require OCA to work with judges to conduct a limited number of jury trials across the state. We have been doing some of that. Those proceedings, jury proceedings can occur both in person and remotely. And so we've been working with several judges to try to do that. Obviously, the key to that is to try to allow us to learn how those proceedings progress and what things we can learn to be able to share with other judges as we look to resuming jury trials throughout the state later on this year. So with regard to OCA's guidance for post-June 1st proceedings, as I mentioned, the Supreme Court's order requires compliance with this guidance, and the latest guidance issued by OCA is really still the one that was issued on May the 4th. As you might know, OCA has been working in the Supreme Court and the Court of Criminal Appeals. We've all been working very closely with the state public health officials throughout this process to try to give the best guidance we could to courts, and we continue to do that. And even in the most recent sort of spike that's going on throughout the state, we believe that the guidance issued on May the 4th is still good guidance, and so we have not amended that at this point. Basically, in addition to requiring everything to be done remotely that can be done remotely, as I mentioned, if a court wants to have any in-person hearings for things that can't be done remotely after June the 1st, there has to be an operating plan in place. And the guidance requires the municipal court's presiding judge to develop that operating plan in conjunction with the local health authority and the mayor. So obviously, every situation in the state, every municipality in the state is not in the same situation from the perspective of the coronavirus at this point, and haven't been even for the last several months. And so we want you all as presiding judges to visit with your local health authority to determine what are the appropriate actions and precautions to put in place in your jurisdiction. To be clear, nothing in any order requires municipal courts or any other court to begin having in-person hearings after June 1st. And really that's a decision that you as a local court and in consultation with your local public health authority should really consider. When is it appropriate, to what degree, those type of things. So again, that decision is really a local decision that we are asking you all to make and the presiding judges to submit for consideration. Obviously, we'd like you to work with your mayor, as you'll see in just a second as we talk about what's required in the operating plan. Several of the requirements implicate perhaps funding issues or supply issues or even building issues. And so obviously, speaking with your city manager, your mayor, those type of folks are going to be really important as part of this whole process. So in the May 4th guidance, it's the one that's still in place. It requires the operating plan to address basically 8 or 9 areas, and you see them listed here. One of them is judge and court staff health. So what precautions, what steps are you going to take to ensure that the judge's health and the court staff health is maintained? So maybe that's plexiglass, maybe that's requirements of mask, maybe that's temperature checks, whatever it is, whatever steps you're going to take to ensure that the judges and court staff, when they are in person with litigants, are that they're kept safe and healthy, as well as that the litigants and others who are coming to the courthouse are protected from the judge and the court staff in case they have any situation going on. So we ask each plan to address that as well. We ask each plan to address scheduling. Obviously, one of the biggest issues with this virus is large groups. And so when we're thinking about a very busy municipal court where sometimes hundreds of people might have gathered in the past, obviously that becomes a pretty significant challenge for us. And so we're asking you to consider how you would schedule cases in such a way to reduce the volume of people at the courthouse. And so that's a component of the plan as well. Third component is vulnerable populations. We know that individuals over 65 and certain others with health conditions are in vulnerable populations, and we define that for you in the plan, the guidance. And so basically we're asking for you to think about how will you address those individuals and those cases where vulnerable populations might be required to come to court under normal circumstances. And so we ask you to take a shot at how you would address that. The fourth issue is looking at social distancing. Obviously, many of our courthouses, our courtrooms, our city buildings are not designed in such a way to be perfect for social distancing. But yet we know that the CDC and the state public health authorities and local health authorities are advising us that people should remain at least 6 feet apart. And so how will you ensure that occurs in your courthouse, in your courtrooms, and your city buildings where people are coming in for court? So we ask you to take a shot at addressing that. The next issue is hygiene. This deals with obviously hand sanitizer, hand washing, mouth, sneezing, coughing, tissues, those type of issues. And we really ask you to take a look at how are you going to ensure that people have access primarily to hand sanitizer, Kleenexes, tissues, those type of things as well. I should say before I move on past social distancing, one of the key issues that's been in place is how to deal with elevators. I know some of your buildings likely have elevators, and we know that having multiple people in an elevator for a period of time can also be problematic. And so we ask you to think about what's the appropriate capacity and how are you going to ensure that people don't crowd into elevators. The next one is screening. Obviously, The recommendations from the state health authority have been that there should be certain questions asked of people coming in. So are they symptomatic currently? Have they been exposed? Do they have other people in their household or around them recently that have been exposed or are symptomatic? Have they tested positive for the virus? Those are type of things that we believe and the health authorities believe should be asked. In addition, one of the things that we are advising is for you to consider temperature checks. We know that that might be something that will help. And so we provide you some information on that, but we ask you to really think about, for your court, what are the appropriate screening mechanisms? Again, we're not mandating certain things be put in place, but we're asking you to develop with your local health authority what those proper tools are. The next one is face coverings. You've obviously heard Governor Abbott, as well as other state and local and national health authorities and officials recommend that everyone should be wearing a face covering. And so we ask you to consider, as far as your local plan, what are you going to require with regard to face coverings? To be clear, OCA nor the Supreme Court are mandating face coverings, but we're obviously highly encouraging those. But there is the ability for you as a local court to consider what you want to do, including and up to mandating face coverings. If you look on the OCA website or the TX Court's website, you'll see that many county and city plans have mandated face coverings, and that's certainly something you can do. But again, that's a local decision that you get to make in conjunction with your local health authority and your mayor. And the last thing I would just point out from the operating plan perspective is we ask you to take a shot at providing information about how you will ensure there's cleaning. One thing we know is that when there's someone coming into an environment right after someone who might have had the virus, obviously we don't want them touching the same surfaces or breathing in the microphone or those type of things. So how are you going to ensure that cleaning occurs? Our guidance actually says that you should consider when there's turnover in the courtroom, that there should be cleaning done during that time. But again, that's something that you and your local health authority and mayor can talk about. There are 2 links at the bottom of this screen. And again, we'll be sending out these materials to you after the webinar. But the link on the left is to the actual guidance. You see a picture of it here on the right side of the screen. But then also on the right side at the bottom, there's a link to a template plan that's in Word, so you can edit it. We just put something out there to kind of get you started. Again, that is a template. You can edit it as much as you want, leave it as long as much as you want. That's really up to you, your local health authority, and your mayor. So basically, once you get done with the operating plan, the guidance will requires you to submit that to the regional presiding judge. As I mentioned, a number of the regional presiding judges are on the call today. Each county and each city is covered by one of 11 regional presiding judges, and that they've been tasked by the Chief Justice and OCA with reviewing these plans, making sure they comply with the Supreme Court's order and the guidance, and then acknowledging that those plans do comply. Once the regional presiding judge acknowledges that, then you are permitted to begin having in-person proceedings in cases where they can't be done remotely. A couple of things that have to come with that plan to the regional presiding judges is some indication, some documentation that the consultation with the local public health authority and the mayor have occurred. Obviously, we want to make sure that that's in place for documentation. There has been some concern raised by some judges about immunity from lawsuits if someone were to be required to come to court, get the virus, and something awful happen. And so obviously making sure we have documentation about that you've followed the guidance and the orders, that you've consulted with local public health authority, and you've consulted with your mayor. Those are all important things that we are requiring to be submitted with the plans. You can go on the txcourts.gov website. At the very top of the screen, there's a banner that actually has the county, the acknowledged county operating plans and the acknowledged municipal operating plans. So if you're not sure whether or not yours is on file, you can go look and see. And if you want to look at other cities to see what they've done, all of them are posted there. You can go look at them. Again, we are here to help you with that process. So if you have any questions, I'll give you an email at the end, but coronavirus@txcourts.gov is our email that we're using for these purposes. But basically, if you have questions, you can let us know. So one of the questions that's already come in here is, based upon local ordinance, the operating plan dates have changed. Do you need to amend? So one of the things that we obviously see happening, especially right now, is that some courts who have submitted operating plans have now, because of the spike, maybe their cities or counties have pulled back, maybe requiring certain things. So it's really up to you as to, obviously you should follow those whatever your city or county are doing, and make sure you're staying compliant with that. And the other thing we would advise you to do is to stay in touch with your local public health authority. As the situation on the ground changes, you should make sure that you are taking every precaution to ensure the health and safety, not only of the court staff and judges, but also of the public and any other individuals who might be coming into your courthouses and courtrooms. So I guess the bottom line answer is, if you need to amend your plan, you can certainly do that. If you, again, like let's just say, for instance, that for whatever reason you chose that maybe on June 1st you started having in-person hearings, but you've now decided based upon your city's, let's just say a stay-at-home order were entered again. I don't think that's happened anywhere, but let's say it was, then you might choose to cease operating under that plan. And then whenever that stay-at-home order is lifted, you could start operating in it again. It doesn't require you to amend your plan unless you're really going to be changing the precautions that are going to be in place. So that's really the key, is what are you doing with regard to that? But otherwise, probably your local operating plan is probably still fine. But again, if you have questions about that, you can speak to the regional presiding judge, or to send an email to the coronavirus@txcourts.gov. Someone's asked a question about what do you do if someone has been having in-person hearings but does not have an operating plan already in place. The 18th order and the 17th order actually address that directly. And what it says is that the regional presiding judges are tasked with ensuring compliance with the Supreme Court's orders and with the OCA guidance. And if there is a situation where someone is not following those orders or the guidance, the regional presiding judges are the ones who are hearing about that. And then they are charged with having a conversation with the local judge or judges in that county or city, trying to remedy that situation. But if they're not able to, then they are required to report that to the Office of the Chief Justice of the Supreme Court, so that there is some sort of statewide knowledge. To my understanding, every situation that's come up where the regional presiding judge has been involved has been resolved. And at this point, I don't believe any judge has been reported to the Office of the Chief Justice. And so hopefully, if that's the situation, that can be remedied. But if there is that situation going on, the place to report that is to the regional presiding judge. One of the questions is, what should you do if the regional presiding judge has not had has had the operating plan for over a month and not issued an approval or denial? I would urge you to reach out to your regional presiding judges. I believe most of the regional presiding judges are approving those plans promptly. We meet every Tuesday and Thursday afternoon with the regional presiding judges, and I know they're approving them promptly. So my guess is, if that's the case and they've had your plan for some amount of time, either it didn't get to them, it's been misplaced, or there's some concern. But I would urge you to reach out to them to visit with them about that plan. So a couple of things I wanted to share with you. We can go back to operating plan questions if you have some. But one of the things that I wanted to show you is just obviously the rise in the number of virtual hearings. Many of you, as well as your colleagues at the county and district level and JP level, have been holding virtual remote hearings for the last several months. And this graph just shows you over time the number of hearings being held per day. You can obviously see the weekends are the blank spots, and you can even see the big dips are actual holidays, being Easter and Memorial Day. But we're now seeing around 4,000 to 5,000 hearings held per day across the state. And that's probably a conservative estimate. We're just estimating the number of cases that are being heard. And I know I've watched some of your proceedings in the municipal courts where there are more than 4 to 5 cases per hearing. So per meeting. So we are seeing somewhere between 4 to 5,000 hearings a day. And that number has not dropped since June 1st, even though in-person proceedings are permitted, showing, I think, that judges are still holding hearings that they can remotely whenever they can. So you'll see that. In addition, I would just point out the number of participants. We've seen the number of participants in hearings drastically increase over the past several months. You can see the number at the end of May got as high as about 14,000 participants per day. So what we're seeing is a lot of participation throughout the state in every case type, from civil, criminal, from the municipal court, JP court, all the way up to the Supreme Court. We're seeing really widespread participation and good success along those lines. So a couple things to think about with regard to virtual hearings. One is, and I know many of you have done this, so you could probably teach this better than me, but for some of you that might not have as much experience or might not have done it yet, I wanted just to go over a couple of things. One thing to know is that when you're having virtual hearings, you and the parties should really treat that just like a courtroom. It's just an online courtroom. One of the things that we've provided, you see this background I'm using today, I'm obviously not sitting in front of the seal, but we've actually posted this picture on our website for judges to use if they want. Obviously, if you have a picture of your courtroom, you could put on there. Just sort of gives the impression that this is truly a formal proceeding. And so you should treat it that way, and so should all the participants. So that means the normal decorum that you would require in court, demeanor you would require in court, and perhaps even the dress code. All of those are things that you can still do. I know some judges have relaxed the dress code because it's an online proceeding, but again, that's up to you. Just remember, it's still a courtroom. It's just we're doing it now online. The second thing is that the constitutional requirements to ensure that there are open courts and that the public access remain, those are not suspended just because we're doing things online. You'll see the Supreme Court's order actually says that subject to constitutional limitations, certain things can happen. And of course, the First and the Sixth Amendments of the United States Constitution require public access and the right of the public to be able to observe the proceedings. And so one of the things that we've really encouraged and said judges should do since the beginning is to ensure that the public has access to the court's proceedings. So even if you're doing a virtual proceeding, you should ensure there's a way for the public to gain access. Most courts during the pandemic have done that by streaming those proceedings live on YouTube through the Zoom platform, which we'll talk a little bit more about in a second. You can just do that with a couple of clicks of a button. I'm doing it today. This meeting is being webcast live, and then that way the public can gain access to it by going to a YouTube channel. With the pandemic we're on this side of it now, it is possible to ensure the public has access. Even if you're doing the proceeding completely remotely, you could place a feed of that into a courtroom at the courthouse and allow that. But again, that would require people to come to the courthouse. So really that's a decision that you need to make. One of the things that you should know, and I'm not sure how often this would come up in your cases, but it might, there may be certain situations where streaming it live would not be appropriate. Maybe there's some sensitive testimony or sensitive case that you think the proceeding needs to be closed. And so we have put out on our website at txcourts.gov a bench card and some legal background about when it's appropriate to close courtroom proceedings and how to do that without violating the First and the Sixth Amendment. To be clear, if you violate that, the case law is pretty clear that the remedy for violation of the open courts or public access is a reversal and new trial. So we're trying to help you not be in that situation. So that information is available on our website. The other thing to remember is that people's due process rights remain. They still have the right to notice, and they still have the right to participate. So as you're thinking about these virtual hearings, really think about how can you ensure they get the appropriate notice and those type of things. The other thing that's right in line with that is some people may have limits in their access. So while I'll show you some survey results in a minute that'll show you that most people have access to participate remotely, obviously we know there are going to be some who don't. So those might be cases where an in-person hearing is appropriate. It might also be a situation where you could provide technology access for them at the courthouse where they could still participate remotely from the courthouse. So I know Travis County is doing that. Some other counties and cities are doing that. So we just encourage you to think about that. And the last thing I would say on this is just remember this is a somewhat still new learning process. We encourage judges and court staff to really start slow with this process. Begin to think about how you can incorporate this. Maybe you do a test with your staff or colleagues on this, and then maybe have a few cases and ultimately increase it to your docket size. I've been watching some of you on YouTube. I know some of the judges are handling dozens of cases in their dockets, sort of returning more back to normal. So we even doing it remotely. So it can be done, and I think you'll see yourself become more and more efficient over time. But those are a couple of things we wanted to point out to you with regard to virtual hearings. So a couple of things with regard to the digital divide. We just recently did some public opinion polling in Texas to kind of see what is the situation with the public's access to technology, how they feel about appearing remotely. And so I wanted to, and I say we had a national public opinion polling firm do this. They surveyed 850 Texans, which allows us to have a pretty scientifically valid poll that shows basically that no matter where we're going to be within plus or minus 3 percentage points of where it would fit. So they looked at rural, urban, all different demographics to try to match the state. So this is what we believe would be the situation in the state. So what we found is that most people have the technology to participate remotely. So we asked them questions about whether or not they had internet at home or high-speed internet at home, whether they had a cell phone or a smartphone. And you'll see a really high percentage of people have internet at home, they have high-speed internet at home, they have a cell phone, or and many of them have a smartphone. So the Zoom platform that we have made available, OCA has made available to all judges to have a free account to do all this with, allows for video participation or just telephone participation. So people can actually call in. And as you can see, whether it's the telephone or a smartphone or cell phone or internet access, most everybody has that. You see only 1% of the respondents did not have internet or cell phone. Now we realize that that number might be a little bit higher in certain parts of the state, but I think overall, from a statewide perspective, most people have access to participate remotely. So you shouldn't let that get in your way in most cases. That being said, if you have a really long proceeding, which I know many of your proceedings are fairly short, but if you have a really long proceeding, what we know from the survey is that people might have limitations in their ability to participate for long periods of time. So not everybody has unlimited minutes and unlimited data. And as you see, 11% of the population who responded don't have either unlimited minutes or unlimited data. So a couple of things I think that points out for municipal courts is to really think about your docketing and scheduling practices. If someone has to wait online for 3 or 4 hours for you to get to their case, they may produce a barrier to them for participation. So we would encourage you to kind of think about that in smaller chunks and maybe schedule your cases along that line. The other thing I would suggest is that you really think about something that we're seeing not only in Texas, but around the country, is that the participation rate of the parties is increasing with remote proceedings. And so by that, I mean that we have less failures to appear in traffic cases and other types of cases that the courts are hearing in our high volume dockets, which your court would certainly be considered one of those high volume dockets. We're also seeing more participation in eviction cases, small claims cases. So really, you should expect to see in your criminal cases and even some of your administrative cases higher participation rates. So just plan for that because it might take you a little bit longer than a normal docket would because of that, and especially in light of the fact that people may have limits in their length of time to participate. Someone's asked a question: if we're having a court by teleconference, how can we have the public access without streaming? So if the public has access to your courtroom or to another room in the courthouse, then you could actually stream that not live on YouTube per se, but over to another courtroom or a place to another place in the building if the public can gain access. We know many court buildings, and there may be really good reason for this, are limiting the public's entry unless they have business. In those cases, really the only way to provide the public access is through the streaming service. So we would encourage you to keep that in mind. I can tell you that it's been kind of interesting to watch the live streams, and I think the public has enjoyed it. The feedback we've heard is they really enjoy the ability to participate and watch what their courts are doing. But it's the streaming on YouTube is not the only choice, but certainly still a choice and certainly something we would still encourage. But if for some reason you don't feel comfortable doing that or you don't think that's appropriate right now, as long as you can put it in a place where the public can gain access, we believe that provides the constitutional ability to participate according to the First and the Sixth Amendment. Another thing about just because everybody has access, how do people feel about using technology to appear remotely? We asked people about how often they use video conferencing services. And you'll see that this number, by the way, is much higher than it was a few years ago nationally. And we've been asking this question nationally, but we just asked in Texas this first year. But it's gone way up about people using it. And most of us probably had not been Zooming, didn't know what a Zoom was before March. But basically, you'll see that more people are using it regularly. You see the age demographics on the right side of the screen at the top. Obviously, the older the population, the less likely they are to have been using it regularly. But that being said, even if they're not using it regularly, we see a pretty significant increase in the percentage of people who are reporting that they're comfortable using it. So again, age demographics matter here because as you see, the older the population, the less comfortable they are. But we believe most people will be able to not only have the access, but be able to use it and be comfortable with it. In the survey we did of the bar, we asked whether or not their clients had issues accessing it or expressed frustration. And those numbers of people who were having issues were very low percentage-wise. So we think that most people can gain access and use the technology. So as you think about developing your operating plans, one of the things I thought might be helpful to you is more data from that public opinion poll. We asked people about jury duty, but I think it applies even in regard to just generally appearing at a courthouse. We asked them how comfortable they would be if certain protective measures were put in place, if they received a summons to come to court. And you'll see we gave them all kinds of options from temperature taking to testing to social distancing, large spaces for them, mask being worn by everybody, access restrictions limit to only people who have to be there, and then everybody wearing a mask throughout their time. And you'll see that all of these are very high percentage of people who felt it would make them more comfortable to appear, which I think the message here the pollster told us really is that people who are coming to our courthouses there's certain basic level of expectation that they believe that we will have to keep them, we will do to keep them safe. But two of these really jump out as kind of issues that people really expect. And one of those is with regard to temperature checking. You see 53% say it would make them much more comfortable, 74% overall say it would make them more comfortable for temperature checking, and that anyone with a fever would be sent home. In addition, they would really like everyone being tested and that people who have active infection will be dismissed. We know that that's not really very possible right now, especially the courts have limitations, and right now I think testing is limited, especially for the courts. And so I think the key message here is think about temperature checking. But the other thing I think that we are recommending to you all as you think about people coming to in person, trying to make sure they know and are reassured of whatever steps that you're taking to keep them safe and healthy. We believe that will, when you have to have in-person proceedings, when remote's not possible, will encourage people to show up in that time. The other question that we asked, which I know many people are asking about, and certainly judges have been asking us about with regard to what to do, is what does the public think about face masks? What we saw is that we asked them if you were required to report in person at the courthouse for jury duty, which of the following best captures the rules you would like to see in place regarding the wearing of masks to reduce the risk of exposure to coronavirus. And you see that 68% of Texans, 67% nationally, think everyone coming into the courthouse should be required to wear a mask. 16% think that it should be encouraged but not required. And then 13% report that there should be no rules regarding masks in the courthouse. So again, this is statewide. There may be differences regionally, although the pollster we did ask them to look at it regionally, and he reported no significant differences by region, rural, urban, whatever. So I think for the most part, we're seeing this is the percentage of people that are supporting these actions. So I'll stop there and answer any questions you have. I know a few more have come in, so I'm gonna look over here and gonna stop sharing my screen just so it's a little easier to see. One of the questions that's come in is, do judges or staff have a problem with defendants getting their phone number? I think one of the things to note here is if you're using the Zoom platform, you don't have to provide the judges, you don't have to provide the judges or court staff telephone number to the public or to litigants. Obviously, what you're providing here is a link to a meeting ID, similar to what you used today when you entered this webinar. And so you can use that, and so you don't have to provide it. We have the system set up actually that even if you call in to the meeting, it masks your number, so you'll see the first 3 digits and the last 3 digits of the phone number only, and so no one really gets the phone number. So I mean, obviously, if you're doing the hearing via telephone, which is permitted, then people may have your telephone number just because of that. But we would encourage you to use the Zoom platform because of the protections it provides. Someone asked a question: is providing the Zoom link to the public via our website and posting notice sufficient for public access? The answer is yes, but let me give you a big, huge warning here on this, which is if you give out your Zoom meeting ID to the public, that is, you've probably heard of Zoom bombing. That is the best way to ensure that someone Zoom bombs you, because if they have the meeting ID, it's like having the keys to the judge's office in the back of the courtroom, because they can get in and do whatever. We would encourage you to only give the meeting ID link to people who you would normally let come into the courtroom right in front of the judge's bench. So those would be participants in the court proceeding. And that anyone else who wants to observe the proceedings, that you should give them a link to the YouTube stream or to tell them that's going to be broadcast into another courtroom. But you don't really want to be sharing or spreading your meeting IDs. That is definitely a worst practice with regard to Zoom meetings. Is you really want to protect that meeting ID. We encourage everyone not to reuse meeting IDs. So if you have a docket this morning, don't always use the same meeting ID every day. Have a meeting ID for this morning's docket, one for this afternoon's docket. That way, people who have access to it can't come back in and do inappropriate things or disrupt your proceedings. So we would encourage you to really keep that in mind. But again, if you post a link on your website to the YouTube stream, that is notice provided to the public. As is pointed out here, the Supreme Court's order requires a notice to the public and reasonable opportunity to participate. So if you do that, the other thing that you do is if you give OCA if you just email to zoomhelp@txcourts.gov a link to your YouTube channel. We actually have on the website a YouTube channel directory. You can go on txcourts.gov right now, go to the YouTube channel directory, and you'll see every court in the state that has provided that to us. There are now close to 1,000 courts that have done that, and it actually shows when they're live, so you can actually go watch those other proceedings. So if you're a municipal court and you're interested in how this works in other municipal courts, that's a great way to do that, is to go watch one of your colleagues in practice. I know we've got a video we'll actually send out with this webinar at the end that shows a couple of your colleagues in action, and they're doing a great job. But obviously, learning from each other is always a really good way to go about this. So someone says that their courtroom has been under construction since before the pandemic. Are we required to hold in-person court? The answer is no. Even if your court wasn't under construction, you're not required to hold in-person court. In fact, you're actually, in some instances, discouraged from holding in-person court, sometimes prohibited from holding in-person court if you can do the proceedings remotely. So we would encourage you to, again, not hold in-person court unless you have to. Obviously, the less exposure people have, the less the risk. But obviously there may be some times where you have to have in-person proceedings. And if so, if you have a plan in place and it can't be done remotely, you are actually authorized to do that. Good question. Someone says, how can we get real-time signatures on documents with the Zoom platform? So there's a couple of ways of doing this. One is that you can actually, you saw me sharing my screen a second ago with the presentation. You could share your screen with a document onto the on here, and then someone, you can actually allow them to annotate, so they can actually draw their signature on there. That's one way, probably one of the more unique ways. You can actually use DocuSign or Adobe Sign to do this. If you email it to someone that has an iPhone, there's a way for them to sign it and send it back to you. So there are multiple ways to do this. Not all of them very easy, but there are ways to do it. And certainly some of your colleagues have been able to do that. But if you have questions about that or need specific assistance with that, let us know. Coronavirus@txcourts.gov or Zoom help, and we'll see if we can get you the assistance that you need. Someone says they're a presiding judge in a very small town, that most of the people don't have smartphones and they use the city council's room for court. They've informed the court clerk they won't have court until October 1st. City doesn't have funds to put up a location, put up a screen. Do you see any problems with this? Would love suggestions. Obviously, we don't know what's going to happen in the fall, so predicting after October 1st is difficult. Certainly, we'll continue to provide updated guidance, and the Supreme Court will continue to update its orders as necessary. But as far as if you're not holding any in-person hearings, no problem with that. If you can hold some remote hearings, obviously, to whatever degree we can assist you with that, we're happy to do so. But that's one thing to keep in mind. If a meeting is streaming, will the court have to paste the recording on YouTube? That is a great question. So we are advising judges so that when you stream it live, it goes on to YouTube. And we're advising judges that there is no requirement to keep it there. And most judges are immediately going on to YouTube. And we give you instructions on how to do this in our guides, to go onto YouTube and either make it private where it's not posted out there, or to delete it. You can do both immediately after the hearing, you or your staff, and that way there's not that permanent record out there. So literally, there's no recording of normal court hearings that's out there for people to watch later, and they can't go back and replay those. And there's no requirement that be the case here either. So our advice to you would be to stream it, go out there as soon as the hearing's over, take it down, and that way that proceeding is not out there. Someone asked for a repeat of where you can go watch the live streams. If you go to txcourts.gov, right at the very top of the page, there's an alert or a banner. You'll see the court YouTube channel directory, and you can click that and go watch your colleagues and other courts around the state do that. Just looking at the questions here. Someone says, if we're conducting limited in-person hearings in municipal court pursuant to an approved plan, is the YouTube link still required? Policy currently is to have only the person before the judge. That's a great question as well. So obviously the requirement is, especially with criminal cases, the Sixth Amendment right to a public trial is implicated, and many of you are handling criminal cases quite often. If the public has to have access to your courtroom, in some way or another. So that's either physically being present in your courtroom, or you have to provide some other mechanism for them to do that. So if your current policy is to only have the person who is the defendant or a group of defendants in the courtroom, but you're not allowing the public or the press to enter into your courtroom, you would need to find some mechanism to make sure the public has access to that. So the way we've advised some judges on this is to, you could stream, you could put a camera in the courtroom, hook it up to Zoom, stream that. It doesn't have to look like this where you can see everybody's face, as long as they can have some level of access to hear and participate in the hearing remotely. And like I said, that can either be on YouTube, it could be in another courtroom, another room in the building. Just provide notice of where they need to go watch it, and you can do that. Certainly, many judges have limited their courtroom space to only participants in the proceedings because of, you can't only fit so many people now 6 feet apart in a courtroom. And so we've been advising those judges to think about other places to provide the public or the press access to those proceedings. So someone says, can juveniles be seen by Zoom hearings if the parent is present to meet the requirements of juveniles seen by the judge? I'm not sure I fully understand the question, so but I'll try my best to answer it, which is there's no limitation on anyone participating remotely. The court's order right now allows every participant to participate remotely. So if you're talking about a case with juveniles where the parent's required to be with them, if they're in the same room together, they don't have to be on the screen at the same time together. You can, talk to them both and make sure they're both there. But there's no prohibition on who can participate remotely. So certainly you can do that. Someone says, what's the threshold or factors that matter when making a determination of whether to have in-person proceedings? Some judges seem to have an operating plan, having an operating plan to mean things are back to normal. Others feel they should be limited even with an operating plan. What's the responsible position? So one is the Supreme Court's order very clearly says courts must use all reasonable efforts to hold proceedings remotely. So number one is, has the judge used all reasonable efforts to conduct the proceeding remotely is kind of a basic question. And then the question is not whether or not the judge really likes to do it or whether it's really convenient for the judge. The question is, can it be done remotely? And most of the barriers that we're seeing with this are where the parties don't have the ability to participate remotely. So maybe they don't have the technology, maybe they can't figure it out. But blanket, and we've had some judges reach out and say, well, nobody in my jurisdiction can do this. We think that's probably not reasonable. Most people we believe can participate in what we're seeing in the state. I've heard judges even on the call yesterday say, this judge said he's in rural East Texas, and he said he's not seen an issue with people being able to participate. So again, that's what we suggest. And what we also suggest to you is that if you have a question about whether or not you feel like something should be in person or not, and you want to see kind of what the thoughts are, you should feel free to reach out to your regional presiding judges. That's what they're there for, to help answer those type of questions if you have that. So reach out to them. So a good question about, are Zoom hearings recorded? That is up to you. There is no requirement that they be recorded. Unless you have some other provision that requires you to record it and retain it. There's nothing special about having to record it this way. If you're a court of record, you may already have some provisions with regard to recording, and you should just continue to follow whatever you were doing before. But with regard to Zoom hearings, no particular need to do that. And most judges in the state are not recording their hearings. They're letting the official record, whatever that may have been before, still be the official record. So courts that had a court reporter are still using a court reporter. Courts that had recording devices to capture that are still using those. There's no reason why you couldn't use the court recording if you were permitted previously to let that be the official record. There's no reason why you couldn't use the Zoom recording, and you should use the same retention schedules that you've always used with regard to that. Someone says, if the court's operating plan requires masks and other PPE and plexiglass barriers, is there a funding source for courts to pay for it? Grants, some cities are not wanting to pay for it out of their budget. We are working on that. Obviously, cities and counties, especially the more urban ones and some of the rural ones as well, received funding from the federal government through the CARES Act. You should ask your city about whether or not there is funding through the CARES Act to cover the cost of PPE and other types of plexiglass and any other sort of costs like that. But we realize that some cities and counties have limitations on that. But that's really a decision you need to have a conversation with your mayor about. Your local disaster folks, whoever's in charge of disaster relief, can be a good resource for you on that. And again, we're working to try to get some funding for courts to assist them. We understand that this is a big issue. You may or may not know that courts actually are the largest government convener of people. So in Texas last year, on an average day, 325,000 people entered a courthouse. That's 1% of the population. And so obviously we have an obligation to get this right, because if we don't get it right, we will potentially set our state and our country back in the recovery. So clearly looking to make sure we have the stuff we need to do this well is important. So again, CARES Act funding, something you should talk to your mayor, city council, city manager about, as well as perhaps to your disaster folks. If for some reason you have issues getting access to supplies, we've been in touch with the Texas Department of Emergency Management and the governor's office, and we are able to try to assist you with that. So if for some reason you're having issues getting access, again, coronavirus at txcourts.gov is a place to go for that, and we can see what we can do to help you. Again, go to your local folks first, because they're going to be quicker. But if your local folks are having issues, you can reach out to us. Question: if we hold in-person proceedings, does that open a judge up to liability or a complaint with the Commission on Judicial Conduct because of the risk of COVID-19? So a couple of things. Obviously we are in a situation where we've never been before. I think there are concerns which could be valid that holding an in-person proceeding when you could do it remotely and when the order requires you to do it remotely could potentially subject some liability if someone were to get sick and there be issues. A court would have to figure out what that is. Your judicial, I think many people have argued that judicial immunity would not apply in those situations because it's more in your administrative requirement of the way you've set up your court or requiring people to come in. But again, that's a question that's sort of open out there. Obviously, we're advising people strongly to, number one, do everything remotely you can to reduce that risk of liability. Number two, talk to your local public health authority to set up a plan that does everything that they suggest to ensure the health and safety of anyone who might be coming into your court, and to make sure that you continue to follow that plan, whatever that plan is that's put in place. Those are kind of key issues. Same thing would go with the State Commission on Judicial Conduct. Obviously, all judges are required to follow the Supreme Court's orders. So the things I talked to you early on about in-person proceedings only occurring when you can't do it remotely, or having an operating plan before you have in-person hearings and consulting, all those things that you should do. Certainly those reduce your risk from a liability perspective, but also in places where there might be a complaint filed against you. So I don't know if we have a minute or so left. I don't know if any of the other presiding judges have anything they want to say either on that or anything else, and then we'll wrap things up. Anybody have anything? They're all shaking their heads no. So if you don't know who your regional presiding judge is and you've not had a great deal of interaction with them before, you should reach out to them. They are a tremendous resource both for you and for us. Again, there are 11 of them. They're covered by counties. So if you're in one of those counties, they're covering your city court. So one thing I would just tell you, and this answers a question, is that if you go to txcourts.gov, across the banner at the top, I've been talking about it a few times, there's several things. One is court guidance. You can find all the guidance we've talked about here today. You can find the county and city plans that have been put in. You can find the court YouTube directory. The other thing that's there that I think is really great is a whole list of resources about how to hold remote hearings. So we call it sort of our Zoom electronic hearing resource page. You can go look there and find that. If you don't have access to Zoom yet, we again bought licenses for every Texas judge. We still have plenty of those left. So if you're a judge or a court that wants access to that, you'll just reach out to Zoom help at txcourts.gov. Anything Zoom related, go to Zoom help at txcourts.gov, send an email to them. They'll be able to get back with you and assist you. We're happy to provide that, and we'll continue to provide that probably forever, to be honest, but certainly at least through the end of the pandemic and over the next several months. So I encourage you to take to look at that. All right, well, thank you all so much. Appreciate your time today, and we will talk to you all soon. Thanks for all the work you're doing. Stay safe, stay healthy, and if you have any questions, again, coronavirus at txcourts.gov or Zoom help. Thanks so much. Have a good day.